2 new reasons for K1 fiancé visa denial. Today, we are going to talk about 2 new reasons there now exist for K1 fiancé visa denial. After President Trump came into office, many changes were made at immigration. 2 of these changes were implemented when the application for a K1 fiancé visa, the I-129F, was last revised. The addition of 2 questions, a total of just 60 easily overlooked words, has caused many applicants expensive and time-consuming extra work to demonstrate their eligibility for a fiancé visa. And for those who did not correctly answer the new questions, well, some have already gotten denied. And please watch to the end, because towards the end of this video, I will explain what you need to watch for and what to do in case you are one of those affected by these changes. I am Fred Wall, the VisaCoach, and I'm here to help you safely navigate a confusing and frustrating immigration process, well, to finally get your fiancé or spouse visa and for your happy life together in the USA that you deserve. Now, let's talk about 2 new reasons for K1 fiancé visa denial. Under President Trump's watch, major changes were made to the application form used for a fiancé visa. These modifications greatly changed the I-129F. Previously, it was 6 pages long, and now it's 13. Some of the new questions that have been added are sure to cause problems for many applicants. Previously, the American sponsor was asked whether he had been convicted for a few but very serious crimes, such as domestic violence, child abuse, murder, rape, or 3 or more drug or alcohol convictions. Those who had those convictions were, well, automatically ineligible to apply for the visa. And if an American sponsor had been convicted of such crimes, well, he already knew he would have problems in applying. It wasn't any surprise. He expected the extra hurdles and were prepared to address them. And in some cases, we could apply for waivers and obtain approval for the fiancé visa regardless of a checkered past. But now, 2 new questions have been added, and these are often overlooked. And ignoring them may cause delays and denial. And addressing them is an extra hurdle you must jump. These 2 questions are, number 1, has the American sponsor ever been subject of any type of restraining order or protection order? Number 2, has the American sponsor ever been arrested, cited, charged, indicted, convicted, fined, or imprisoned for any law, any ordinance, any time? Now let's start with the first one about restraining or protection orders. These could be something serious from the past. However, more often I find that these were issued as part of contentious divorces, as well strategy versus real cause and need. In many cases, the ex-spouse's attorney had advised to issue restraining orders in order to obtain leverage during negotiations for child custody and property settlements. As our fiancé visa sponsor wasn't really a person who had done anything to merit a protection order, he may have tried to put the painful breakup and divorce out of his mind and forgotten the specifics of the divorce process. Well, if he does forget and fails to answer the question correctly, his fiancé visa is in jeopardy of denial. The second new question is even more all-encompassing. Any crime, any arrest, any convictions. Well, this covers a lot of ground. That arrest for trespassing when you as a teenager skateboarded on school grounds after closing. The time you were removed from a bar after defending a friend who was in an argument. The time you were driving the car and a police search ended up with the police finding contraband that belonged to your passenger, but you as a driver got charged for it. And so on and so on. Of course, most of these issues were probably forgotten, having occurred long, long ago, sometimes many, many decades earlier. And oftentimes a judge or lawyer or someone in authority said, "Don't worry about it. This will not be on your permanent records. The records will be erased or expunged." Well, expunged, on or off the books, forgotten, no matter what, if it ever occurred, whenever it ever occurred, in order to apply for a fiancé visa, the answer must be given yes and details provided. If one innocently forgets and neglects to answer the question accurately, well, he runs the risk that when the FBI, with all of their resources and all of their oversight, finds out that the answer should have been yes, but you didn't admit it, well, your application is ready to be denied. The new issue is not what the crime was, but whether or not you honestly admitted it. To be found inaccurate on any of the immigration questions, regardless of how apparently immaterial or irrelevant they may seem, can be grounds for denial. So be warned. Under President Trump and the policy to restrict legal immigration, you will be faced with booby traps and problems like never before. Now, more than ever, inexperience can lead to mistakes that cause delays and denials. The safest way to navigate the system to obtain your happy life in the USA that, well, you and your loved one deserves is by choosing someone who is knowledgeable to help you. Choose someone who is always aware of any rule or policy changes, intimately aware of how the system works, where the traps and quicksand are, and who is here to help you successfully get visa approval. And of course, I mean me. This was Fred Wall, the Visa Coach. Now please like or add your comments to this video, and then go to VisaCoach.com and sign up for the VisaCoach monthly newsletter. Each month it is full of tips and advice on marriage-based immigration and free of charge. And when you sign up, you get 2 free ebooks I have written. 120 K1 visa interview practice questions, and 5 things you must know before starting on your visa. Now finally, when you are ready to get started, call for your complimentary case evaluation and speak with me directly.
Before starting on your immigration adventure, before entering an arcane maze of rules, regulations, and procedures, before committing yourself to a risky path that could mean an end to your happiness, speak with a Visa Coach and ask for his free case evaluation. He listens to you to learn the red flags and strengths of your case, your eligibility and goals. He will suggest which visa is right for you, the best strategy to get it, and how soon your love could join you. Visa Coach's friendly advice and support might make the difference between approval and denial, and could save you months or years of loneliness and separation. What have you got to lose? Book your free evaluation today.